Ian was supposed to do that too. Court does call the case, People versus Unique Haywood.
This case opens with tension already simmering beneath the surface. We have Unique Haywood standing before Judge Simpson on a pre-trial that immediately derails into a bond violation inquiry. That shift alone tells you everything. The court isn't here for formalities. The priority is compliance, truthfulness, and public safety. And when a judge pivots to violations before anything else, that means the red flags aren't small. They're waving hard enough to stop the entire proceeding. From the very start, pay attention to the defense's tone. They're already on the defensive, already trying to soften the impact of positive alcohol tests. But Judge Simpson isn't someone who accepts vague explanations or guesswork. This is a judge who knows testing science, who knows timelines, who knows what ETGs can and cannot detect. And as you'll see, he pushes hard on inconsistencies because, bottom line, the court's trust has already been damaged. The key players today, Unique Haywood, accused of violating bond with repeated positive alcohol tests. Defense counsel, trying to build a narrative around ETG delays, vapes, toothpaste, and anything that could explain away alcohol readings. Judge Simpson, who immediately signals skepticism, precision, and absolutely no patience for unclear stories. Community corrections, whose reports and instructions become crucial. This case isn't just about whether alcohol was consumed. It's about responsibility, program compliance, credibility, and how even minor actions, like using a vape, can spiral into major courtroom consequences when the rules are strict and unwavering. As we move through the timestamps, watch how the explanations shift, how the judge reacts, and how the timeline exposes cracks in the story. And ask yourself, if you were the judge and kept seeing positive tests with no clear answer, would you trust the defendant's explanations? This is where the drama begins.
Good morning, Assistant Public Defender Lauren on behalf of Ms. Haywood. Please.
Unique Haywood.
Your Honor, we are here today for a pretrial. There also is a bond violation in
Oh, yeah,
file.
there is. Why don't we deal with that first?
Sure. So, as you can see in the bond violation report, Ms. Haywood, for the first chunk of positive tests, did do an ETG test, which did come back negative for alcohol. She has, and that ETG should cover the period for those positive tests. Since then, she did have another positive test. I think the last one.
Which ones are you talking about the ETG covered?
She took the ETG on the 15th
Of March,
of March.
right? But that doesn't cover, that might cover the 12th, the 13th, and you're saying the 14th.
Right,
Okay.
right. Because the ETGs go back 72 hours from when she took them.
Yeah, I know how they work. Go ahead.
So she had another positive test, as the court can see. She was going to get another ETG done yesterday. However, she was at work and was unable to do so. I've spoken with Agent Mormon about it, and we haven't really come to a conclusion of what she thinks is triggering the positive test.
Oh, it's certainly not brushing your teeth.
This moment defines the tone of the hearing. Judge Simpson is not buying soft excuses. When he says it's certainly not brushing your teeth, he shuts down a defense narrative that had zero scientific support to begin with. ETG tests and breath analyzers don't light up because of toothpaste, and the judge knows it. What he's doing here is exposing a broader issue. If the explanations keep shifting, it usually means the truth hasn't been stated yet. Defense first floated toothpaste. Now they're floating a vape. The judge's response makes one thing clear. The credibility of these explanations is slipping fast. And remember the stakes. Bond conditions are strict because the defendant had a prior alcohol-related case. When someone is on a sobriety monitoring program, even trace amounts trigger consequences. But here's the deeper issue. When someone keeps offering new theories each time they test positive, how does the court distinguish between a misunderstanding, negligence, and deliberate non-compliance? The judge is highlighting exactly that uncertainty, and he's signaling he won't accept speculative guesses. Audience question: do you think the defense should have presented hard evidence before showing up with claims about vapes? Should they have tested the vape, checked ingredients, or brought documentation? Lawyers know that judges expect proof, not possibilities.
No. She initially thought it was brushing her teeth. She now thinks it was a nicotine vape. That she was instructed to not blow 30 minutes before. She's been waiting 45 minutes and she hasn't had a positive test since changing that. So what I'm asking.
Why aren't I getting retest?
No. The reason why I did the retest the first couple of days was because I wasn't notified that the machine will actually tell me to retest. I thought that there was something that Mr. Mormon was going to have to reset, like off site. So that is my fault and my irresponsibility for that.
So I'd ask Judge if she could do it
Well,
ETG
hold on.
today.
Hold on. On the 16th, my problem with an ETG today is it doesn't tell me anything about the 16th.
Right, because of the 72 hours.
And so what I have before me right now is a positive test and no explanation for it.
This is where Judge Simpson drills straight into the core of the issue. The court has positive alcohol readings, repeatedly, and no verified explanation. Notice how he strips away every side argument and focuses on the uncontested facts. In court, speculations don't matter. Narratives don't matter. Only verifiable evidence matters. Defense is trying to paint a picture of an unknown substance triggering the results, but the judge forces them back to basics. Show me proof. Without documentation, toxicity reports, chemical analysis, or expert testimony, the court must default to what the device recorded. And when a defendant has already been warned about avoiding alcohol-containing products, even accidental ingestion becomes a violation if they failed to check. What's more telling is the timeline inconsistency. If the vape caused the positives, why weren't earlier tests affected? Why did readings drop sharply after 18 minutes? Why did retests show the same problem if the defendant waited? These patterns matter, and the judge clearly doesn't think the data aligns with the vape explanation. Think about it. Should a judge trust a timeline that only partially matches the defense's theory, or does a pattern of positives point to intentional or negligent alcohol exposure?
Well, I suppose our explanation would be the vape issue. I mean, she maintains that she has not drank. She has this vape. She started using the vape when she was told at arraignment not to drink and not to consume marijuana.
Even if the vape has alcohol in it, which I don't think it would, but even if it does, she can't inhale or do anything with alcohol.
Yeah, I mean, I don't know why the vape would trigger the positive test. She's had continued positive at very small amounts. So that's our only explanation. I mean, again,
Here's the problem with that. The problem with that, even if you're talking a half an hour range, look at the very bottom of the report on the 16th. She submits a positive test at a 0.2, correct? There is then almost 20 minutes later, 18 minutes to be exact, there is a positive test. Again.
I don't have an explanation for it, Judge. I mean, if she was drinking, frankly, I don't know if we'd see that sharp reduction.
That's not a sharp reduction. That's a reduction.
I mean, going from 0.026 to 0.019 in 18 minutes, I don't know if it was alcohol.
Within the margin of error? Really, counsel?
I mean, she has consistently maintained that she has not drank alcohol. When she did have a positive test, she did an ETG and it was negative. So I think that explains that there's something else going on that she's consuming that we aren't aware of, that is triggering these positive tests.
And you need to bring me something that says a vape's going to do it. Because otherwise, what I have in front of me now, that she has a positive test. And then it's positive on the retest.
Yeah, no, I
And
mean,
moreover, if it's indeed true, she was instructed not to take the vape prior to testing.
yeah, she has been waiting for a longer period since the positive test, and she hasn't had one since making that change. Again, we don't know. I've had many conversations with Miss Haywood about if it was her toothpaste. I just think that
It's that if she wants to go with it being her toothpaste, then
no, we've come to realize that we think it's the vape because since she's waited longer, she hasn't had any positive tests.
where's the vape?
The vape's in my car at the moment.
This detail, the vape is in the car, is more important than it sounds. If the vape was truly the centerpiece of the defense's explanation, one would expect it to be ready to present. Instead, it's outside, untested, unverified, and unavailable for immediate inspection. That weakens the argument dramatically. Courts rely on clarity. If an item is allegedly responsible for multiple violations, it should be brought in, analyzed, documented, or at minimum described in detail. Here, we learn nothing about the vape's brand, ingredients, composition, or alcohol content. Defense also hasn't brought literature or studies showing vapes causing false breathalyzer positives. Without such support, the entire theory becomes circumstantial at best. The judge's frustration is visible. He wants concrete evidence, not speculation. If the vape is the cause, prove it. But until then, the only concrete fact is, the defendant has multiple positives and failed to retest as required. This moment also shows how small oversights, like not bringing the vape inside, can devastate a defense strategy. Everything hinges on that evidence, yet it wasn't prioritized. Ask yourself, if your freedom depended on proving a vape caused false readings, wouldn't you bring it to court first thing?
It's in the car. All right. Then you're going to need to get some information on this vape. But right now, she's got a warrant out for arrest. She's here on an OWI 2. And I've got positive tests coming back. You've given me somewhat of an explanation for the other positive test, but I don't have an explanation for this one. It doesn't work that way. So is there somebody that can go out and get it?
She's here with her family. Her father can go get it.
Come go get it. It's in my purse. The keys are in the car. It's in my purse. It's in the car.
Because right now, like I said, she has a warrant for arrest. So she's going to have to go into custody until we can figure this out.
They briefly told me that they can call for an alteration in my results. That's the exact reason why they told me to wait at least 30 minutes prior to taking my test. So during my debriefing, when they were giving me my sober link, they did tell me that the vape is capable of causing an alteration in my results. And that's why they said that they recommend to wait at least 30 minutes prior to taking the test. And the vape is the only thing that's altered in my normal routine. I never thought that it was any type of toothpaste or anything like that, which I told Mr. Mormon as well.
The report indicates you said something about it being toothpaste.
Mormon, he asked me the same thing, and I told him that I've always told him that I believe that it was my vape because that's the only thing that's altered in my daily license being released. And they also told me that the vape is the only thing that would alter it. But they told me that I had at least 30 minutes, and I had been waiting longer than that. And now that I no longer even use it, it's fine.
I think that explains the positive tests, frankly. I mean, with the first test positive.
Here, defense is trying to regain narrative control by asserting that the vape is the only changed variable. But this is where the tension rises. Judge Simpson has repeatedly heard claims that don't match the data. When defense argues that the vape explains everything, the judge pushes back because the timeline contradicts it. Mid-commentary relative to original dialogue, the defendant claims she always believed the vape was the cause. Yet earlier, toothpaste was mentioned. These contradictory statements matter because they undermine reliability. The judge references the program rules. Participants must check every product they consume. Even if the vape didn't contain alcohol, something in it could interfere with the device, meaning she should have sought clarification or stopped using it immediately. The judge also highlights another critical flaw. The defendant repeatedly failed to retest. Retests are mandatory specifically to rule out contamination. Failing them removes the possibility of blaming the device or a product. Then there's the science. If the vape caused positives, earlier tests after receiving the unit should have shown it too, but they didn't. So the judge isn't rejecting the vape explanation emotionally. He's rejecting it logically. Engagement question. Should courts accept explanations that contradict the timeline? Or must defendants provide hard evidence before asking judges to overturn device results?
She was again asked if it was the vape causing the positive test. She asked if it was the vape. She was then advised that it's her responsibility to check all products that she's using to see if they contain alcohol.
Yeah,
And that's the absolute truth. That's the absolute part of the program.
I mean, I don't
It's
know.
her responsibility.
Right. And I think she knows that. We've had conversations about that. I also don't know if the vape, even if it doesn't contain alcohol, does something sober like the device that positive test.
Excuse me?
I mean, maybe there's something in the smoke that malfunctions the sober link or something. I mean, I just don't know how
Oh,
she.
you want to go with that argument?
I don't know enough about the sober links, frankly, but I mean, I just don't understand. She has a positive test. She took the ETG. The ETG was negative. But we're still having the same issue. And as she said, the only thing that we can think of is this vape.
We'll wait for the vape, let you do your research, convince me that she should be released because right now she has a warrant. I won't send her back for processing at this point. Let's put her over in the jury box, get that in there, and then you bring me something, counsel.
This is the judge giving defense one last opportunity. Bring evidence, bring documentation, bring science. If the vape truly interferes with the sober link device, the court is willing to investigate, but not on verbal claims alone. This is critical because it shows fairness. The judge isn't shutting down the possibility. He's requiring real proof. But here's the bigger picture. The judge also acknowledges the seriousness of a warrant, repeated positives, and program failures. It means even while they investigate the vape, the defendant cannot simply walk out. The system prioritizes safety and compliance over convenience. There's also a strategic shift. The court is requiring defense to come back with research. That's unusual. Judges usually rely on probation officers or experts. Here, the burden falls heavily on defense because their theory contradicts established patterns. This raises an important point for viewers. Courts don't operate on what might have happened. They operate on what can be proven. Without evidence, even plausible explanations fall apart. Engagement question. If the vape turns out to have zero alcohol content, what does that mean for the defendant's credibility?
Court does recall the case of People versus Unique Haywood.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Ms. Haywood. Ms. Haywood, please state your name for the record.
Unique Haywood.
Is there anything else you want to say regarding these bond violations?
Your Honor, I did, thank you for the opportunity to speak with my client. She, at this time, does not admit to consuming alcohol. We did, off the record, speak about the possibility of alcohol from a vape. She wants the court to know she takes full responsibility for using a vape. She reiterated to me she didn't know that it consumed alcohol. She does take responsibility for.
Okay. I'll let you go on, but can you just stop right there for a moment? Because there's a number of different problems with this whole argument. Some of which have to do with sort of the global picture of things. With the number of people that vape, I would be seeing this all of the time if it were that vape. That's the first thing. Second thing is, and I certainly will let you continue, but one of the things that's bothering me is the issue isn't necessarily drinking. She cannot consume any product or in any way consume or ingest any alcohol. Those are the rules of the program. And I know it's explained to you. It's explained to you in excruciating detail. She is also, upon a positive test, for whatever the reason, is supposed to retest. She did not retest. She's not following any of the rules of the program. She did not retest after her initial one on the 12th, the one on the 13th, she didn't retest.
This stretch is devastating for the defense. Judge Simpson lists each retest the defendant failed to complete, 4 separate dates where she did not follow mandatory procedures. This is more damaging than any positive test because retests are designed to verify or disprove readings. By skipping them, the defendant unintentionally eliminated her own ability to claim innocence. The judge's tone reflects deep concern. Failing to retest isn't a minor slip. It's considered non-compliance. And in monitoring programs, non-compliance often carries the same consequence as confirmed alcohol consumption. The rules were explained in excruciating detail, meaning she was fully aware of expectations. Defense tries to pivot back to the vape, but the judge systematically dismantles that narrative. If the vape was the issue, then early dates, like March 10th and 11, should have shown positives. But they didn't. That contradiction undermines the vape theory entirely. The judge's analysis is methodical. He traces the dates, the timeline, the device behavior, and the defendant's actions. And when the story doesn't line up, he treats it as unreliable. Audience question: if a defendant misses multiple required retests, should the court still give them the benefit of the doubt? Or is strict enforcement necessary to keep the monitoring program credible?
On the 14th, she didn't retest. On the 16th, she didn't retest. Oddly, then on the 16th, there's a positive test. There are actually 2. She does retest. She didn't retest immediately, but she retested and then contacted community corrections. She's the one, according to this, that brings up the vape. According to what was said to me before, that they were then supposed to wait, say, a half an hour or so before she tested if that was it, but they did remind her that she's responsible. She then, 45 minutes after that phone call, submits another test. It comes back positive again. So I'm having a little bit of a difficulty believing that that's it. I also will say, and again, I'll let you continue on, that had it been the vape, she received the unit on March 9th. Which means, and she did a compliant test on March 9th. That means then on March 10th, March 11th, I would have had positive tests. I don't. I don't have, unless somebody's just vapes occasionally.
The last 2 points I wanted to make, Your Honor, she does take responsibility for not retesting. She says she should have been more diligent at looking at the device after she tested. As for your last point about when she got the device, when she started testing positive, she normally does not vape. She started using the vape after she got the device. So that's why when she says she hasn't, that's the only thing that she thinks it is because that's the only thing she's changed out of her normal routine from when she got the device to now. And that's all I wanted to say.
Then I still would have had a positive test on 10 or 11, the 10th and the 11th, if that were indeed the case.
When did you start vaping? I purchased my vape on the 12th.
Yeah, of course.
I did. When did you start using it? I started using it. I used it on the 12th that morning. Okay.
Anything else?
I mean, I would reiterate my request, Your Honor, to have her do an ETG today, switch her to a scram tether, and adjourn this out to see if she continues having tests in order for her not to use any nicotine or vaping products.
Does she want a hearing on this, or is she admitting to the violation? I mean, I'm not sure what you're doing here.
Here, the courtroom reaches a procedural crossroads. Judge Simpson asks the critical question, is the defendant admitting to the violation or contesting it? This matters because it determines whether the court proceeds immediately or schedules a formal violation hearing. Defense chooses a hearing, a strategic move that buys time, allows evidence gathering, and avoids an on-the-spot admission that could lead to immediate sanctions. But this choice comes with consequences. The judge now expects hard evidence at the next hearing, not theories. And by choosing a hearing, the defense essentially signals that they believe they can disprove the violation, a high bar considering repeated positives and failed retests. The judge also references scheduling with precision, indicating he expects significant disagreement during the hearing. When judges foresee complex arguments, they reserve longer slots. This moment also tells you something about the judge's mindset. He's giving the defendant due process, but he is clearly skeptical. And in law, skepticism isn't hostility, it's scrutiny. Engagement question. Would you choose to admit the violation and ask for leniency, or request a hearing and try to fight the results? Which strategy seems stronger in this case?
I mean, if she does neither, I'm going to set it for a hearing. So I mean, she doesn't have to say. But
Your Honor, let's set it for a hearing, please.
set this for a bond violation hearing. Your normal date would be the 3rd, but since she may likely be in custody, I'll set this for March 27th, 2024. That's a special time at 9 a.m. for the bond violation hearing. What is the alleged BAC in this case? I see that there's a prior.
Yes, Your Honor. In this case, the alleged BAC is a .192, and there was a crash, a single motor vehicle crash.
I didn't do the arraignment, so how long?
She was on probation for operating while visually impaired out of the 34th district. That conviction entered on August 3rd of 2023. The offense date on this is January 22nd, 2024.
Got it. All right, I'll set a bond hearing for that March 27, 2024 date at 9 a.m. Defendant's bond is reset. Your bond is going to be $25,000. I'll give a 10% privilege on that. However, prior to any release, if she posts that bond, she's to be placed on a scram tether prior to her release. Defendant is remanded.
Thank you.
Is Ms. Haywood here?
She went to go download the screen.
Okay, they had indicated to me, or at least the information I got back is, we won't get anything today.
We will get essentially an indication if there's something that needs to be reviewed by the scram expert.
Got it.
What we will not get is confirmation of an alcohol consumption event.
Because they have to, right?
Correct. But there will be an indication if something needs to be reviewed as a potential alcohol consumption event.
Okay, let's do this then. What I'm inclined to do is adjourn this to the 10th. The people don't need to have their witnesses available. And that way we can monitor it and make a decision as to whether or not you need to proceed forth with the hearing. Does that make sense?
That works.
Okay. So I'll adjourn it to April 10th at 1.
It's actually
At 9. Okay, April. Right, it'll likely go to the afternoon, but I'll set it for April 10th, 2024 at 9. But we'll likely set that in the afternoon.
Okay.
But I'll say for the hearing in pretrial.
And she can go, we're not gonna hold it.
Great. She can go. Her bond will continue. because she posted and it's on the scram. So, all right.
This case ends with a structured but serious outcome. Judge Simpson resets bond at $25,000 with a 10% privilege, then imposes a scram tether, which offers continuous alcohol monitoring. This move signals the court's lack of confidence in the current monitoring results and its desire for a more reliable, tamper-resistant system. The hearing is adjourned until April 10th, giving time to gather more information about whether the vape could have interfered. But the judge makes it very clear that without scientific proof, the vape narrative will not stand on its own. What you're seeing here is the intersection of law, technology, responsibility, and credibility. The court is balancing due process with public safety. The defendant is navigating strict rules and the heavy consequences of non-compliance. And the defense is racing to align their theory with the timeline, science, and evidence. A difficult task given the inconsistencies. Big takeaway: sobriety monitoring programs are unforgiving because they must be. One missed step, whether intentional or not, can trigger cascading legal consequences. The judge's role is to protect integrity, fairness, and accuracy, and he fulfills that role with precision. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.